Right, I think we're going to get a bit of a contrarian view now from Gert Nel, Managing Partner of Gert Nel Incorporated Attorneys. Thank you very much. He's going to speak about the future of the South African personal injury law practice. Thanks very much, Gert.
Thank you very much, and thank you to everyone making time to listen to us today. My assignment is to give a perspective of what's to be expected of the personal injury attorney in the future. And I'm going to focus primarily on the Road Accident Fund because that's the arena that we or us are dealing with. Having regard to where we are at the moment, unfortunately, information is very limited in terms of the new strategy of the Road Accident Fund, but we do know that they intend to make the system more accessible, more streamlined, and cost effective. Now, in order to facilitate or initiate this process, the Road Accident Fund opted not to renew the contracts of the panel attorneys. They decided to, or there is mention made, as Dania said, of mediation as a possible way to solve the problem of settling matters quickly. My concern is that in terms of costs and the administration around the whole mediation process and the fact that there's no legal binding power to mediation, I'm a bit concerned that that might not be the solution on the long term, because it might just be more expensive than we are currently seeing the Road Accident Fund having to pay for litigation. There has been mention made of a special RAF tribunal that would be headed by a judge, so that might be a possibility to facilitate the earlier settlements of these matters. The Road Accident Fund obviously has also mentioned that they will or are going to try and settle matters within 120 days. Now, all of us in this field knows that 120 days is not a practical goal, but in terms of where the Road Accident Fund is going, having regard to the fact that they are busy setting up what we call or what would be regarded as a settlement hub. More or less what we saw with, in the 90s when the MMF, the predecessor of the RAF, was in place, you had claims handlers that were legally trained. Many of them were admitted attorneys. They all had mandates and they were all capable of settling matters. In those days, when you received the summons, you were called into your manager's office and you had to explain yourself. So litigation was limited to the very few matters that were very complicated and could not be resolved otherwise. So I foresee that that is the route that the Road Accident Fund is taking, and I would presume that the block settlement route will preempt anything else, be it mediation, a tribunal, or having to go to court eventually to try and settle a matter. And I think the view of the Road Accident Fund, or the approach would be, is to compile a panel of exceptionally qualified people to attend to this block settlement hub, because the efficiency of that hub would depend on people that can go toe to toe with well-seasoned plaintiff attorneys. And in order to achieve the goal of settling matters earlier, Dani mentioned the fact that we can reasonably expect to settle matters at least 2 years earlier than we are currently seeing. So that would entail a total rethink of the way that you practice, because to a large extent litigation would be a thing of the past, and with things as they are at court at the moment, I think that's a blessing, because I think we're all aware of the complications and the additional strain that we have to take as a result of practice directives that are just impractical, and that's making the access to courts of our clients very difficult at the moment. So I'm very positive about what's happening, and the fact that the fund is extending a hand to plaintiff attorneys to engage them directly. I must say, before lockdown, when the first news broke of a new strategy by the Road Accident Fund, and then complete silence, had us all worried about what was going to happen post lockdown to our clients. And I must say, I was quite surprised and to see that the Road Accident Fund actually stepped up to the plate, and they are settling matters. The previous term, our firm and from what I've heard, other firms did quite well, and even in this term, the Road Accident Fund is really coming to the party, and having regard to the limited resources that they've got, I think they're actually doing a sterling job in settling matters and making sure that traction is kept. And at the moment, they are attending primarily to matters that are on the trial roll. So, but you know, if that backlog has been worked out, obviously this settlement hub of them, I think, would be the answer. So I think, you know, in short, if the Road Accident Fund strategy works, it's a win-win situation to us all, because we will settle claims earlier, the RAF will settle or manage to save costs, and we as plaintiff attorneys will be able to remain in the arena, because the alternative, as Peter has alluded to earlier, is the benefit scheme. And under the benefit scheme, there's no future for attorneys. So we need to work together with the fund, assist as far as possible. We might not be able to settle claims in 120 days, but I think we can make an effort to and use it as a goal to compile and rather prepare claims more diligently prior to filing or lodging the claims with the RAF than having to depend on litigation to connect the dots and putting unnecessary strain on the Road Accident Fund.
Thank you very much for that, Gert.